Hi, good evening, everyone. We have our instructor today, Mr. Srinivasan. So he's going to take us through the clauses of an LLP agreement and how to draft them. And he will also be looking at the assignment and going over it with you guys. Okay. So I'm asking Mr. Srinivasan to start the class.
Okay, I'm sure you've had a go through about this assignment. No, there were four problems, if I understand right. Correct? Okay, so I had a quick glance at about three or four assignments. So today, what we'll do is we'll just go through the problems. Okay, there were about four problems. One problem, the first one had two sub problems, if I can call that. Then so totally we had four problems, very interesting ones. So we'll discuss what those problems are today, and maybe I'll provide an indication to you as to how you could proceed, because drafting is an art, right? Drafting an agreement is an art. So there's no like this is the correct answer, that is the correct answer. That. So when maybe you can have a look at what possible ways that you can draft an LLP agreement on those problems, and then maybe in the next 1 week you can sit through and then draft those agreements and see, and then send a fresh one on maybe 5th or 6th, so that it's easy for me and I can have a look at it, and we can then maybe discuss those drafts, right? Okay. So let me just go through a few introductory slides. Are you able to see the slide?
Yes, sir.
Okay, great. So this is how we'll proceed. We'll maybe for 5 minutes, I just take you through an introductory slide or two on drafting LLP agreements. Then we'll go through each and every assignment. So there are, like I told you, 4 problems. Let's see. Okay. And just feel free to interrupt me whenever you want to, right? There is no restriction that you need to kind of ask questions later or in the chat box. Just feel free to interrupt me whenever you want. Right. So before that, I think there are 3 or 4 participants only. So if you can just introduce yourself very briefly and tell me what is the course that you've gone through, this particular course that you've gone through so far. What have you learned broadly and stuff? Then it will be easy for me to tweak my sessions accordingly. Before you do your introduction, let me do my introduction. I am Badrinath Srinivasan. I work in an organization called as Directorate General of Hydrocarbons, which is a part of the Ministry of Petroleum and Natural Gas. I finished my LLM in law. So this is basically my background. I've been working for the past 15 years, if I may say, 15 years, in various organizations. I've handled domestic and international transactions and domestic and international dispute resolution. I've also handled legal compliances and things like that, right? So this is basically my background. If you can start off, it'll be great. Yeah, any one of you can volunteer and let me know.
So good evening, sir. I'm Varun Pathania, and I've been currently I'm practicing in Himachal Pradesh High Court and also the district courts within Himachal Pradesh. I'm a beginner, just a beginner, so I'm a junior associate there in the High.
So I'm also a beginner, so no need to.
Okay, sir. So further in this course, what we have, what I have learned till now is that the basic concepts, I mean, the forms of business organizations like the partnership, LLPs, and the companies, their forms and what procedures are required to be incorporated, how LLPs and companies are to be incorporated, and what are the different entities and agency concepts within them. And now we are pursuing with the contracts class, and in this class we have learned the general understanding of contracts and how we have to approach the contracts. We have been given a book by Mr. Ajab Rab, so I've read that book. So the basic gist I know that how to approach the contracts, like how the language should be put in the contract, like the active voices and in the present tense, and all the things like representation, warranties, indemnities, the various things which make a contract complete. So that's what I've learned till now. Thank you.
Have you ever drafted a contract?
I'm drafting now. I mean, in a real life scenario, I haven't drafted a contract, but the mood drafts I've drafted them. Also, in real life, I've reviewed the contracts. I mean, whenever the dispute with respect to some contract was there, then we reviewed that contract, like where are the where the things can come go in our favor.
Yeah, thank you.
Good evening, sir. This is Shruti Sharan, and I'm in third year of the BBA LLB 5-year integrated program from Karnavati University, Gujarat. Till now, as Varun said, we have done the basics. Initially, we started with the sources of law, like the primary and secondary sources, like the very basics. And then we proceeded on to the forms of organizations and which organization is suitable for what conditions, like we were given assignments respectively for each of them. And then now we have proceeded towards contract drafting. And I have done internships under AOR, Mr. Rahul Krishna sir, and I've worked on few slum sale agreements, and I've drafted other tasks were related to bail applications, so drafting clauses in that. And so it was quite diverse, not very specific, but as I worked on those case laws, some were competition law cases also, so I developed an interest in commercial laws. So I want to proceed towards that now. So yes, that's why I opted for this course.
Got it. Yeah. Anybody else who would like to speak? Okay. As and when people join, let them introduce themselves. So we'll proceed like this. Okay. Now the time is approximately 6:20. So we'll break the session into 2 sessions. Okay. Maybe at around 6:50, we'll break for 5 minutes, 6:50 to 6:55, and then the remaining we'll see. Okay. So I understand that all of you are coming from different backgrounds and having different experiences. Some of you are students and some of you are practitioners. It's okay, no problem. So that wouldn't really make me change my preparation for this. Okay, let's first deal with what an agreement does. See, why do you reduce your oral discussions to an agreement? So this is something that you would have already seen in your sessions. Okay, especially have you looked at my videos on this?
Yes, sir.
Okay, so the introductory portion will contain why you need to draft agreements. Basically, to ensure that, see, we tend to forget, so ensure that those transactions and what was agreed is exactly available to the parties. Parties will forget, and change of circumstances will mean that some of the parties will try to engage in opportunistic behavior and things. Okay. So, but what you need to understand is that agreements address situations and risks. Okay. To give you a simple example, what will happen if one of the partners to the LLP becomes insolvent? Okay. This is the situation, right? Then let's say that let's just take another scenario where one of the partner wants to exit the partnership. Okay, so this is a situation, but that situation also leads to a problem. What is that problem? Say if that partner wants to exit the partnership and wants to sell his interest to a third party whom the existing partners don't like, for example. Okay, then that becomes a risk or a problem. Right? So all agreements, whatever may be the case, address risks and situations. Right? So what is risk? Risk is nothing but an uncertainty of outcome. Okay. And the possibility that the actual outcome may be different from what was expected. Okay. So you take any clause in an agreement, whichever may be the agreement, whether it is your slum sale agreement or whether it is a simple agreement for buying and selling vegetables, oral agreement that you have with a vendor for buying and selling vegetables, even the simplest of the agreements to the most complicated agreements, like for example, shareholders agreements and all. So all these address risks and situations. Okay, now if you are clear with that, then the first problem becomes very easy, because what the first problem does is it asks you to bring out the risks inherent in the or involved in the particular transaction that it explains. Okay, we'll come to that. Now, there is also another type of or another objective with which agreements are drafted. Those are formal or declaratory clauses or provisions. So every agreement, if it is reduced in writing, will have these formal or declaratory provisions. For example, parties. So and so parties having its registered office at so and so place, which includes its permitted assigns, transferees, legal hires, etc., etc. Okay, so these things you see, these are formal provisions. Likewise, recitals. Okay, so one of the parties, that is the contractor, the client was interested in, let's say, developing a software for implementing in its organization, say accounting software for implementing in its organization. The contractor or the service provider has expressed that he is having expertise in developing accounting software, and has represented that he would provide a fit for purpose software for the client's purposes. Accordingly, both parties agree as follows. This is a very simple recital. Okay, so these are also formal or declaratory aspects of an agreement. Likewise, the definitions. Now, coming to LLP, the name of the LLP, the clause providing for name of LLP, is a formal or a declaratory part. But you should note one thing, that same formal or declaratory part may have substantive impact. Okay, the very same 3 or 4 clauses that we saw, let's say the party, you will find in most of the agreements that when defining one party, it will say that party includes assignee, heir, succession, successor, etc. Okay, so now this is having substantive impact because it is covering not only that party but also a legal heir. Okay, so it is possible that the agreement may be binding upon the legal heir. Okay, tomorrow a dispute may arise on the death of one partner, whether the arbitration clause in the partnership or the LLP agreement will be binding on the legal heir. So this clause, although it is formal in nature, may have substantive impact. Okay, so likewise, you see recitals. Now recitals not only contain formal useless parts, it also contains very useful parts. Just for example, I told you just now regarding this recital, where the contractor or the service provider represents that he is having expertise in developing this accounting software. So the way in which, or the manner of performance of a normal person will be different, or the standard of performance of a normal person will be different, and the standard of performance of an expert will be different. So if dispute arises, a normal person will say, look, I tried to develop the software in a particular way, but this glitch happened. So I'm not very familiar with this accounting concepts, and that's why this glitch happened. He can say that. But an expert cannot say that, because he's an expert in developing accounting software. So the standard of performance will be higher for him. The threshold of performance will be higher. So therefore, although the recital is having a formal part, it has substantive impact. Likewise, let's take the case of name of LLP. In name of LLP, you find section 15 of the LLP Act, which says that whenever LLP the name of LLP is used, it should be accompanied by the suffix LLP or limited liability partnership, right? And if you don't do that, that is wrong, right? You are met with some sanctions provided by law. Okay, so the two lessons that we learn is that an agreement also contains formal or declaratory provisions. This is the first lesson. And the second lesson that we learn is that although they are formal or declaratory, they may, in specific circumstances, have substantive impact. So therefore, we see now, apart from this formal or declaratory, we find that agreements address risks and situations, right? Now, what are the kinds of situations or risks that agreements address? We can see it in the context of LLPs. So, supposing there is a LLP that is running, right? Suddenly they would want, the partners would want additional contribution. There are five partners, assume, in an LLP. Okay, so suddenly they would want to expand their business, okay, for which they need some capital. Now, the question arises, who among those five partners will provide that capital, right? So then what, then if there is a clause on contribution, okay? In every LLP agreement, there is a clause on contribution. That clause will address this particular situation. Okay, likewise, there is also another thing. Let's say that an LLP runs, and then it in the first year of its business, it incurs a loss of about 5 crore rupees. Again, there are 5 partners. How do you share the losses? In the sense that who will contribute to those losses, right? Now that is provided by a clause. This situation is addressed by a clause regarding sharing of profits and losses, right? Similarly, there is a possibility or a risk of an existing partner being sidelined. Let's assume that there are 4 brothers and 1 external partner, right? Now these 4 brothers might conspire and try to kick out the external partner. Or maybe among these 4 brothers, 3 brothers might conspire against 1 brother. So therefore, there is a possibility of sidelining existing partner. Okay, now to address this risk, what are the clauses that could be used? One is regarding admission of a new partner or removal of an existing partner. So these clauses could address those risks. Note that this is just an illustration, right? Then deadlock in decision making. What happens when there is a deadlock in decision making? I think this is the subject of your third and the last assignment problem. You've been asked to draft a clause on deadlock, right? So what happens? So one of the clauses that addresses this particular situation is voting rights. How many votes does each partner have, for example? Then there is a clause specifically on how to address deadlocks. That is also there. Then there is a clause on simple majority. Now, what happens in a situation where the simple majority, say, let's say that there are 5 partners, each partner has 20% shares. I mean, 20% interest in the partnership. So among the 5 partners, 3 partners can take over and dominate the other 2 partners, right? In this example I gave you. So that risk is there. So how will you address this? You will address this through a clause regarding voting rights. Then you will reserve certain critical matters for a decision by all the partners, unanimity, right? So these are various ways in which you could address this particular situation. Then what? Then there is a risk of dispute among partners. Then what happens? Then how to resolve this? So you use a dispute resolution clause. Okay. So the lesson that you learn from this slide is that so there are various situations and risks, and each such risk could be addressed through 1 or more clauses, right? Okay. Now let's come to the first assignment. So what is the thing that is being asked of you? So to identify the possible risks that could arise during the execution of this agreement, and they have provided you a risk matrix also, or a table, to put it in simple. So there is a serial number, and what is the risk, and how will you address this? Okay, so if you want to do that, this is one of the ways. I mean, serial number column is missing, that's okay, but this is a risk or a situation that is listed here, and this is how you can resolve the risk in the third column, the second column. Okay, so I've just provided you an illustration as to how you can address that particular. See, so this is a risk, for example, deadlock in decision making, and how you could resolve it through a voting rights. Okay, great. So this is how you do it. But see, in practice, what happens is that you may not have the time. See, you might be working, say, as an in-house counsel. Okay, suddenly, or an associate in a law firm. I understand many of you are interested in the corporate sector and want to move to the corporate sector, right? So you are planning to work for possibly in a law firm. Suddenly, your partner or your senior associate might come and tell you, look, draft an LLP agreement. And this might be the first time you would have drafted it. But what you need to understand is that you need to understand that that there are only risks and situation apart from declaratory provisions or clauses that any agreement will address. This you have it in the. Secondly, what are the possible risks and situations that can come up? Okay, and then you think about all these things. Seasoned lawyers will mentally think about all these things and address those situations. But if you're a beginner, one way to list down all the risks or situations is through a checklist. Okay, checklists are very important. Okay, that because especially for a beginner, see, seasoned contract drafters, if you ask them to draft an agreement, say those who are having 20, 25 years experience, they'll start and they'll stop. And in that time, when they start, they will draft the entire agreement or they'll dictate the entire agreement. Okay, so that is how thorough they are with contract drafting. But as beginners, what we need to do is that we need to have checklists. For different types of agreements, you have different checklists. Okay, see, when I joined my first organization, which was Gujarat State Petroleum Corporation, I first had a checklist for agreements generally. Okay, then I had another checklist for agreements relating to sale or purchase of goods. So there was an agreement checklist generally, then for goods, and then for services. Okay, so most of the time, what happens is that you tend to vet agreements rather than draft them. Okay, so this checklist will help you to see if what are the clauses that are to be there and what are missing. Number one. Number two, that is a shortcut for your risk or a situation map. Okay, that is number two. Number three, if you want to draft an agreement, that will really help you because you just take your checklist. Okay, first is the title of the agreement. Then you put that. Then you go to the next one. Next item in the checklist is say parties, and then you also provide in your checklist that parties should also include permitted assigns, legal hires, and all that. By the way, what is this permitted assigns or permitted assignees? Any idea?
So the original party who have who may permit these assignees as to become the partners themselves.
But why is it called permitted assignees? Why not just simply assignees? Don't worry. I mean, if you don't answer, also it's not a problem. Most of us don't know. Okay, so that's okay.
So because they've been authorized to do the work.
Yeah. So what happens is that, see, if there is an agreement between two parties, right? So by law, unless the agreement otherwise provides, the law of assignment states that you can assign a right, okay, without consent of the party to the contract. But when it comes to obligations, no, you cannot assign your obligations. Okay. So, so if you want to assign your obligation, like for example, let us take a simplest case of 100 kg of rice. Two parties enter into an agreement for supply or purchase of 100 kg of rice. Okay. Now, you can very well tell the supplier, if you're the purchaser, that look, you don't deliver that rice to me, you deliver that rice to my neighbor. Okay, but the supplier cannot say that, look, you take your 100 kg of rice not from me, but from some other person. Okay, notice that what you could assign without consent was a right, but what you cannot assign without consent is an obligation. Here, the obligation that you could not assign was the supply of the goods, right? So this is the law of assignment. In India, the assignment law is not codified. Okay, so it is common law based, right? So that is the reason why you have this word permitted before assignments. Got it? And this is the default position in law. Okay, you can contract around by saying that even if you want to assign a right under the contract, you need to seek my consent. You get it? Any problems in understanding?
No, sir.
Okay. Great. Okay. So that is why you use the permitted assignment. Yeah. So coming back to the assignment problem 1A, so you use this risk matrix and list down. Okay. So every exercise in this assignment is based on certain fact situations. No. Now let us see what is it fact situation. LLP is being negotiated. There is no LLP as such, it is being negotiated by two partners. Partner A has a majority interest of 60%. Okay. Partner B has a minority interest of 40%. Okay. Mr. A is going to oversee the operations and management of the LLP. Right? And Mr. B is going to oversee the sales and marketing of the LLP. Okay. So this is the fact situation. And now the problem also helps us, okay, in this fact situation by saying a few more things. Risk identification, I mean, you've been given the option. You can identify the risk from the perspective of A or from B or both. Okay, so look, risk identification is always perspective based. If you are, say, a buyer, you will have certain set of risks. If you are a seller, you will have certain set of risks, and both might be different, right? Now, if you are a service receiver, then your risks will be different, and so is the case with the service provider. To give you the simplest example, let's assume that you need a particular equipment. So you've entered into a purchase agreement. Okay, let's say that you are a manufacturer of cars. Okay, now you have entered into an agreement for purchase of engines from, let's say, Suzuki. Okay. Now, only if Suzuki delivers it by 30th of April, will you be able to supply to your customers by 1st of May. Okay. And if Suzuki delays it by a day, you will lose 1 crore rupees. Okay. Now, the risk that as a manufacturer you have is the possibility of your supplier, that is Suzuki, delaying it. And the consequence of that risk is that you may incur 1 crore rupees of losses. Whereas for Suzuki, a mere delay of 1 day may not have any impact on it. You get it? So in a transaction, the risk from the perspective of the car manufacturer is totally different from the risk from the perspective of the supplier. Okay. And now the problem says, if you want to identify the risks for both, that is great. But it is sufficient for you. I mean, the person who drafted this problem is very lenient towards you. He says that, look, it is sufficient if you draft it from one person's perspective. Okay, so that option has been given. And what we discussed just now, that is what this problem also says. The risks associated with the performance of this contract, the LLP agreement, would be different depending on your perspective. Okay, so this is what has been asked. Now, you have any thoughts on this problem?
We had, I mean.
Okay, yeah,
yes.
You can proceed.
Thoughts, I mean, according to this problem, I had prepared a list of the risks and how to mitigate them on behalf of both the parties.
Okay. I'll have a look at it. Now, let me do something for you. I mean, if you have done with it, then great. But if you're not done with it, because see, what happened is that I have received about 3 or 4 assignments only out of a total of 15. You have 15 people in all? 15, 16, I think. So I have received only 4 or 5, and I found that few of those 4 or 5 have not addressed this in great detail. But no problem. See, if you have to address or identify all the risks, then that will be like a huge list running to about 30 or 40 items at least. Okay. By the way, you've been given how many sample LLPs?
3 samples, sir.
Okay.
3.
Did you have that look at that Ambani sample, which was like 50 pages?
Yes, sir.
Yes.
I mean,
That was a pretty big one. I have gone through the entire agreement, but not with the level of focus that needs to.
If you sit and start reading, it will take 2 days, 2 whole days to read, no?
Yeah.
Okay,
Yes,
no
sure.
See, I'll tell you what happens in practice. Generally, in practice, LLP agreements are not as complicated. Okay, but very rarely LLP agreements are complicated. So therefore, in most of the situations, real life situations, you will not get an agreement that is as complicated. Okay, maybe if the amount if the transaction involves Ambani's or some people like that, then maybe it might be complicated. But that's okay. So don't worry. Looking at that Ambani sample and think that LLP agreements are very complicated. That's what I said. No matter what the agreement is, if you are able to list out the situations and risks, then that's it. Okay, now we'll see what are the possible ways in which you can do the drafting. I'll provide an illustrative list. Maybe then that will help you out. Okay, so here in this problem, what happens? Let me get back to the slide. A has majority interest, right? B has minority interest, correct? Okay, so therefore what happens? Therefore, B is at a disadvantage. Okay, and note that in the problem, A is overseeing the management of the LLP. Okay, and A has 60%. He is having a majority interest. B has only 40%. So, if a decision regarding the LLP requires only a simple majority, what is simple majority? Yeah, in this case, anything above 50% is a simple majority.
Yes.
Right. So, so therefore, A has 60%. So, if the LLP provides for simple majority for the decisions, then what will happen?
A will.
Yeah, go ahead.
A will overpower B, or maybe misuse that interest to.
Yeah. So in that case, what happens? See, I've just listed out a few disadvantages. One is unilaterally A can decide. Then if A wants, he finds that, look, I don't want B, I don't like him. He's performing well, but I don't like him. Let's just say that that's what A thinks. He can throw him out. Or he can say, even if the agreement provides that, say, you need a 75% majority. And then but then the agreement also says that if you want to bring in a new partner, you need a simple majority. Okay, let's just say that for expanding the business, you need 75% majority. But for bringing a new partner, you just need a simple majority. Then what can happen? Then A can bring in 2 or 3 new partners, right? And then they will provide their contribution. If they provide their contribution, then that will lead to a dilution of B's contribution. You get it? See, this dilution we'll discuss in detail in probably the next class. This is just a percentage, no?
So, sir, I had just one question. So this 60% interest A is having, I mean, it will also reflect in the voting share as well, or they can,
Yes, possibly. Because if the agreement provides, that's what, no, if you recollect, 3 or 4 slides back, I explained this to you. If you see deadlock in decision making, voting rights, you saw this. So,
yes, sir.
So most LLPs provide that your voting share is in consonance with your contribution or your interest, right? So then what happens? Then it may lead to a dilution if you bring in new partners, right? So that and then risk of improper accounts. If A has the control over the management, right? So he might not maintain the accounts properly. He might hive off the profits, which is maybe which B may be entitled to. Look at this transaction. A is just overseeing the management, and B is doing all the hard work. What is B doing here? B is
sales and doing the sales.
The most difficult and important aspects of the business that is being handled by B, but the entire power is being possessed by A. Correct? Because it is involved in operations and management of the business. So that means they can hire employees, they can fire. A can hire employees, it can fire employees. So A can do whatever he wants. But whereas B is just going to the customers, getting hold of customers, then selling the products or services or whatever, earning money. So A is doing all the donkey's work, and B is doing all the donkey's work, and A is just enjoying it, right? So this is the kind of transaction. So if you've already done this, keeping all these in mind, your risk matrix, then well and good. But if you have not done, then maybe you can sit again and then have a look at it, right? Now, problems that are common to both parties are usually situations and risks. Okay, accountability, whether A is accountable to B, likewise whether B is accountable to A. For example, let's just say that B, on the garb of say going and marketing this product, goes to hill stations during summer, stays there, enjoys, and says that, look, I don't have any customer. Okay, that possibility is also there. So accountability is a problem that is common to both parties. Then parallel competition. Let's say that although A has majority, B is running a parallel business in the same area. Okay, B owns the same business in the same area. Then there is competition. So that is a risk for A also. Likewise, if A has a parallel say entity running in the same business, then that is a problem. Then there is a deadlock in decision making. Both don't agree. Then what happens? Then the obligation to render true accounts. Okay, although operations and management is handled by A, then say for example, B incurs certain expenditure in the course of the work. Okay, that he has to account for to A sincerely and properly. So that obligation is mutual. Now let's come to A. We might think that A will not have any problems. A will have problems. Let's, like I told you, fraud in the course of business or marketing. Okay. Then B is acting beyond authority. Authority provided is something, and B is acting beyond authority. Okay. And B is acting in a manner that is contrary to the interests of the firm. B says, look, B says to his customer, look, the product's price is 1,000 rupees, but instead of 1,000 rupees, you quote 1,200 rupees. And I will sell it to you. And that 200 rupees extra, you give me 180 rupees and you pocket 20 rupees. I mean, I'm just giving a simple example so that you can understand, but usually the prices will be in the range of millions and sometimes billions also. Then imagine the under the table earnings that we might get. So this is a risk for A, right? So the risks are for both A and B separately, and common risks and situations as well. Based on this, now you can draft your risk, right? I've just given you an illustration. There are so many other illustrations, so many other things that you look at. You start reading an LLP, you will look at how it addresses a particular situation or risk. Okay. Any questions?
So running a parallel competition and the obligation to render true accounts, all these can come under the fraud, generally under the fraud that you considered a problem for A itself.
Yeah, that's true. That's true. How you want to address this is up to you. Question is whether it is adequate or not. Now, what is fraud? Can you tell me? In simple, no need to give me a legal definition. Okay, like how that professor gives in 3 Idiots movie. No need to give like that. Simple definition or simple meaning. What is fraud?
Purporting to be something else on paper.
Okay, let me just help you that fraud is a representation of something to be true when the person who is representing it knows it to be false. This yes. Is one of plus this. Okay, he knows it to be false, but still he says that no, it is true. Okay, now this is an example of a fraud, or this is one possible way of defining fraud. Now, is running a parallel competition a fraud?
If it is like contrary to the interest, obviously it will be the contrary to the interest of the agreement already entered into. So
let's just say that person who's say B is running a parallel business. Now he's running a business, but he is selling the products in the same geographical area, but he's not soliciting the customers of this LLP. Is it fraud?
Pardon, so he's not?
He's not soliciting the customers of this LLP, but he's selling that same product for different customers. His own proprietorship concern, same product, but for different customers. Is it acting in the interest or against?
It will be a fraud.
So where is the representation here?
So that's why in the agreement it has to be specified that
exactly. Exactly. Now that is the point that I'm looking at. See, there might be situations where it might not be clear. Okay. So rather than have an omnibus clause, which says that no partner shall act contrary to the interest of the firm, you say that, and you also say a specific thing that you will not enter into or you will not run a parallel competition. Okay, just so that there are no ambiguities, right? So you specify that also, right? Any other question? Feel free to ask.
Yes, sir.
Yeah, good.
For that question in which we were saying that Mr. A had 60% interest and Mr. B has 40% interest. So in order to mitigate that, we can write in the LLP that although the profit sharing will be according to the proportion of 60 to 40%, but the voting rights will be equal. I mean, when we'll draft the voting right clause, we'll say 50 there.
Absolutely. That's not a problem at all. See, it's at the end of the day agreement. So as long as any clause in the agreement does not contravene public policy, those are enforceable.
So I have a few questions. So with your permission, I may ask them at the end of the lecture.
Whichever suits you.
Okay, sir. So in the LLPs, draft LLPs, which were given to us, after the name of the parties, there's a line that the individual party shall be said as party, and plurally they'll be pulled as parties. So isn't this this is an interpretation? I mean, so why isn't we are writing it in the interpretation clause? I mean, we have the interpretation clause in the agreement, and this line, according to me, what I believe is just in how to interpret the agreement. Like the individual should be said as party and plural should be said as parties. So in maximum agreements, this line is written not in the interpretation clause, but at the earlier stage. So I mean,
I got it. There's no problem. I mean, you can do it either way. That's not a problem. But what happens? See, sometimes in the recitals, you'll need to use the word party and parties. Okay. So therefore, this clause is placed just below the parties, description of the parties. That purpose only. You want to place it in the interpretation clause, nothing wrong. You can do it, and then you can say in the recitals that whenever you use the term party in the recitals, as here and after defined, or as defined hereafter. That's not a problem. Really, nothing wrong.
Okay, sir. And so, and yes, sir, is transfer to affiliate different from transfer of interest generally? I mean,
yes. See, what happens is that you know very well that even a corporate entity can be a party to the LLP. Correct? You've studied that. Sir. Right. So what happens is that sometimes corporate restructuring takes place. Say suddenly one company would want to demerge one of its business and have it in a separate entity, or it might want to merge all its subsidiary into one. So all these possibilities are there. So that corporate restructuring keeps happening in an entity. So what will happen is every time a corporate restructuring takes place, you need not take the consent of the partners, of the remaining partners, not to just park off your interest to your affiliate. So that's why generally a transfer to affiliate has less restrictions than transfer to a third party.
Okay, so I mean, in the act itself, it says that in transfer to when there is transfer of interest by any partner, then that partner to whom the things have been interest has been transferred cannot operate in day-to-day management, and only he will be entitled to only the rights and profits of the partner who is transferring. So because of that,
can you read that provision? Which provision does say that?
Yes, just a second, sir. Yeah, it is section 42, partners transferable interest. I mean, the rights of a partner to a share of profits and losses of limited liability partnership and to receive distributions in accordance with the limited liability partnership agreement are transferable either wholly or in part. The transfer of any right by any partner pursuant to subsection 1 does not by itself cause the disassociation of the partner or a dissociation and winding up of the limited liability partnership. The transfer of right pursuant to this section does not by itself entitle the transferee or assignee to participate in the management or conduct of the activities of the LLP or access information concerning the transactions of the LLP. So this third section, it says that any assignee or transferee, he cannot participate in the management or conduct of the activities.
Yeah, so it all depends on the agreement. See, even if you hold an interest in the partnership or LLP, that doesn't mean that you have a right to vote on certain resolutions. Okay, like for example, the agreement itself might provide that so and so person will not have voting rights. He'll only be entitled to the profits and losses. Okay, so
yes,
although he may own, say, he may have contributed 20% and he may have share the profits to the extent of 20% and losses to the extent of 20%, he will not have any voting rights. The agreement might provide that. So even that's what this clause says, that even if you transfer your right to a transferee, that doesn't mean that he has a right to participate in the day-to-day business of the partnership or an LLP.
Yes, that's what it says, that if you transfer profits, then that person is only entitled to profits and he'll not participate in the management.
No, it does not say that. It says that merely because you transfer your interest to somebody or assign your interest to somebody does not mean that you will have an automatic right of participation in the day-to-day affairs of the company unless the agreement otherwise provides. Okay, if the agreement provides that the assignee or the transferee will have a right to vote on 20%, will have a right to participate in the business of the partnership, then that right will hold good, notwithstanding this clause.
Okay, sir. So if agreement provides, then they can transfer the voting rights as well.
Yeah. So what happens is that, see, if you recollect, I think in the first few minutes of the class on drafting partnerships and LLP agreements, you would have seen something called as default rules and mandate rules, right? If you don't recollect, have a look at those videos once again. You will find that default rules are rules that can be contracted around by the parties. Okay, but whereas mandatory rules are basically public policy related rules which cannot be contracted around by the parties. So to put it in simple, so therefore your LLP Act, when it deals with the inter se rights and obligations of the parties and the rights and obligations between the LLP and the partners, it is more or less default rules. Okay, most of it is default rules when it relates to these aspects. But whereas when it relates to aspects like registration and all, no, those are mandatory. Okay, yes, so therefore this is also a default rule. The provision which we saw, if the parties have an agreement to the contrary, then that's enforceable.
Okay, sir.
Sir, I have one small doubt.
Yeah. So just to add on this question, sir, I have this doubt then wouldn't it amount to, indirectly adding a new partner? I mean, I'm a partner, I give some voting rights to another partner. Wouldn't it amount to like adding an extra partner without the consent of other partners?
That is why you have a clause where you say that if you want to transfer your interest, then you will have to seek the consent of the other. Then you remember a few minutes back we discussed this concept of permitted assignees.
Yes, sir.
Yeah. So that. Okay. Yeah. Somebody
yes,
else. I mean, yours is complete, or you still have a few more doubts?
Sir, I have one doubt, sir.
We can do one thing. Mr. Varun has a lot of doubts. Let him finish it. Then we'll go to the others. Yeah, please go ahead.
Thank you, sir. So So okay, second doubt is connected to this. So my third doubt was like that, like right of first refusal, right of first offer. In the agreement, these were under the title transfer of interest. So what I wanted to ask is that shouldn't this be under the clause cessation? I mean, when partner ceases to exist, then only the other partner wants to quit or wants to sell, then only the other partners these rights kick in. So my question was then why these are given under the
It
clause
really,
transfer of interest?
I got it.
I
See, it
mean,
really doesn't matter where it is placed because substance trumps form. So under whichever clause you want to put it, you put it as long as it is clear, right?
okay, sir. Okay, sir. And so from that, I mean, right of first offer and right of first refusal, they cannot coexist. I mean, only one can exist according to my understanding.
In the next session, we'll be dealing in detail with this. So at that time, we'll discuss this.
Sure. Okay, sir. Okay, sir. And so this title to property clause, I mean, like LLP, it is a limited liability partnership and like a company, it owns property. So why this clause is added? I mean, in the end, then parties are saying that, okay, all the property of the LLP, some this belongs to me, that belongs to me. Doesn't it make the LLP itself kind of redundant? I mean, in future, if you want to, I mean, why then separate personality has been given to
What
LLP?
happens is that it's not, see, default rules are like that. If parties agreement is silent, then that rule will govern. Okay. But that doesn't stop the parties from dealing only where parties want to contract around the default rule. Okay. Parties might, for the sake of certainty, deal with those aspects in their agreement. So there is nothing really wrong in doing it, so long as whatever you're agreeing to is clear. Right?
Okay, sir. So, I mean, it is upon parties will if they want to, own all of the LLP's assets also, they may do so. Okay, sir. And sir, lastly, what is a duly certified copy? I mean, now this NN Global case also came. I didn't understand this concept of duly certified copy, original contract or its duly certified copy. So, what is it and how to?
I'll have to look at the judgment and I'll have to tell you, because substantive discussion between the majority and the minority judges have been on this particular aspect as to what is the difference or what exactly is a duly certified copy. I'll have to look at it and I'll have to tell you.
No, it is not related to that judgment. I
Does not
mean,
pertain to our lecture, so maybe you can write to me. Then maybe
sure, okay, okay.
I'll revert.
Sure, sir. Thank you.
Okay. Yeah. Any other doubts that you have?
Sir, I have one doubt, sir.
Hanji, please go ahead.
Am I audible?
Yeah, you're audible.
So, sir, some in an LP, if one company is a partner, that's what I heard that you said. If a company is a partner, then how will it get represented? Like that company has to name one of the director or any director will automatically be part of the LLP.
The company will have to nominate a particular person to represent that company in the partnership, in the LLP.
That person will just act like a partner only.
Yeah. It will act on behalf of the company. That person will act on behalf of the company.
Okay, sir. And one doubt I have. Suppose if there are three partners constituting one LLP, and one partner is bringing all the office and machinery in as a capital. So will that property now become of LLP? And like if the LLP suffers losses, then that property may be used, or the partner can save that property.
See, this uncertainty is there. No, that is why it is better to have a specific clause on this particular aspect as to how contributions will be treated.
No, sir. Suppose if there are 20 lakhs contribution and 10 lakh rupees office, I'm one of the partner is bringing. So there is a 20 lakh capital contribution, and of that 20 lakh, 10 lakh is of the office furniture and office space and everything that one of the partner is bringing. Now he want to safeguards what he's bringing in the LLP. He doesn't want to get those assets sold in near future.
No
but
problem.
will that be as a nature of separate legal entity as a LLP? Will that property become the property of LLP?
See, from
all the partners will have share on that.
Legal perspective, the capital that you bring in or the contribution you bring in terms of money and in terms of any other assets are not legally distinguishable. Okay, so assets are nothing but some things, okay, which have the value. Okay, so therefore it is not that unless you bring in money, that will not be treated as a contribution. This will also be treated as a contribution, but it really depends on the agreement between the parties. See, if parties want to treat, say, office furniture as an investment into the company, then they can do so. Nothing prohibits from them.
But sir, at the end of the day, that will be the property in the name of LLP, or
If the intention is to bring it into the property, into the kitty of the LLP, then that's how it is.
sorry, sir, I didn't get you.
No, if the intention of the parties is to treat that office furniture brought in by one of the partners as a property of the LLP, then so be it.
Then it will be of LLP only.
Yeah.
Although in register it may remain as one of the partners.
Yeah.
Okay.
That's also.
And suppose if the LLP suffers losses, then will that property be used to set off the claims of the creditor, or the partner can prevent?
It depends. See what happens. Losses. The LLP incurs losses. So how they'll want to meet out those losses is up to them. If they want to sell those assets and meet up the losses, so be it.
Okay, sir. Got it.
Yeah. Any other questions?
Thank you.
Yeah. Okay. So let's go to the second problem, right? Second problem is also equally interesting. It is a follow-up of the first problem. What is asked here is that how should each of the risks identified in assignment number 1A be addressed in the negotiations? How exactly would you want to negotiate these? Okay. Then it says during the negotiation, what are the kind of risk management or risk aversion techniques that you adopt? And 3, how should each identified risk be addressed in the LLP agreement? See, basically, if you're doing this assignment, then 1 and 2 are basically descriptive, whereas 3 has some direct nexus with the risks that are identified and our discussion. Let's see what we do here. See, what I have done is in the next 1 or 2 slides, I have provided how that each of these risks could be addressed in the agreement. It's an illustration. You can develop your own thoughts on it, right? Yeah. So illustration 1 I provided, risk of B being engaged in a competitive business with that of LLP. So this is one risk. Then illustration 2, risk of Mr. A being the majority shareholder may want to sell his interest in the LLP to a third party or introduce a partner and change the composition of the partnership. So these are specific risk illustrations of risks. Okay, now how will you address those risks? Okay, like if you recollect a few slides back, we were talking about advantages of B, disadvantages of B in that particular 60-40 relationship between them. No, so I've just provided a detailed list of clauses that could be used. See, for example, in serial number 1, we see that A is overseeing the operations and has 60%. There is a risk of B being thrown out. So you address those risks through a removal of partners clause or a legal heirs clause. Okay. Then risk of unilateral decisions. So there are series of clauses through which you can address this particular risk of unilateral decision. One is decision making, then quorum, then you reserve certain matters, right? You reserve certain matters for unanimity, like for example, sale or purchase of property, right? So this is one of the examples commonly called reserved matters, right? Where you reserve certain matters for decision by all the partners. Then certain acts are to be done only after the consent of the partners, of other partners. Then the right to requisition meetings. So see, it is not that the chairman of the LLP only requests for meetings. So it could be possible that say 20% person holding 20% of the interest can call for a meeting of all the partners. So those rights could be provided. Then voting rights and who will be the chairman, how will the chairman be appointed. So these are various ways in which you can address the risk of unilateral decisions. Then accountability, again, right to requisition meetings is a tool for accountability of the majority partners. Then indemnities, then the liability or the obligation to render true accounts and provide full and complete information. Then I gave you an illustration of parallel competition. No? So there is a specific clause that prohibits it, right? Then bringing in new partner, that you could have it as a reserved matter. for which consent of all the partners are required. You can agree on that. And deadlocking decision, dispute resolution clause or a deadlock clause. So these are various illustrations as to how you will address those risks in the LLP. So to put it broadly, the first part of the first problem, part A, was identifying risks, and the second part was how you will address those risks identified in LLP. Okay, so and this is another example. If one partner wants to exit the partnership, then what are the risks that are there, and how will you address it? One is the preemptive rights. What one of your colleagues told, ROFR, ROFO, that is right of first refusal, right of first offer. Then prior notice, like your agreement might say that if a party intends to exit the partnership, he should give 30 days prior notice. Then if you want to admit a new partner, you'll see the consent of the other partners. Then what happens in case of a death of a partner? Okay, then transactions. In respect of transactions, a person should have access to the accounts and the obligation to render true accounts. Then if a partner acts beyond authority, there should be a clause which will deal with authority. What is the authority that is designated? Say, for example, 3 partners are there. All the 3 partners have the authority to operate the accounts. So one partner might withdraw all the money from the partner LLP's accounts and run away. That possibility is there. Then there is a thing called designated partners, who are basically the managers or the main managers of a partnership, right? Then if, say, a person is wanting to act contrary to the interest of the firm, you have a general clause which says that all the partners have a duty to act in the best interest of the firm at all times. So these are various examples of risks and how they are usually identified in the LLP agreement. By the way, there is a instruction from ABC Learning says that mark your attendance. So please do that in case you have not seen the chat box. Okay, so let's go to assignment 2. Now in assignment 2, what is asked? You've been asked to draft a capital contribution and profit and loss clause. Okay, based on a given scenario. We'll see what that given scenario is. Then you've been asked to draft an indemnity clause, again based on a particular scenario. And C, you've been asked to draft a cessation and retirement of the existing partners clause and a winding up clause of the LLP, right? So what is the scenario that is given? ABC LLP is a newly formed LLP that will engage in the business of providing IT consulting services to its clients. The partners of ABC LLP are Mr. A and Mr. B. Both are equal partners. And A will be responsible for managing the day-to-day operations, and B will be responsible for operations and management of the LLP. So B will actually have the control over the operations and management, and A will do the day-to-day work, right? So in this given scenario, you'll have to draft those clauses: capital contribution, profit loss, indemnity, cessation, retirement, and winding up. So these 6 clauses you've been asked to draft. Correct? So what exactly is capital contribution? Capital is a wealth in the form of a money or any other assets owned by a person or an organization, or is available for a purpose such as starting an organization. So this is a general definition. Now, contribution. So your clause should say how will the initial capital be contributed, who will contribute, and how much each person will contribute. Okay, so your clause should say this. Then your clause should say, it should say it in terms of percentage and amount. Then further contributions, what will happen in case further contributions are required, and how further contributions will be calculated, and who will provide those further contributions. And then what is the procedure for making further contributions, and how to withdraw your contribution. So your capital contribution clause will address all these situations. Okay. Now let's go to indemnity clause. See, if you look at any basic LLP, you will have at least 2 or 3 types of indemnity clauses in the LLP. One is a clause indemnifying the partners, and one is a clause indemnifying the LLP. And I've just provided here an illustration of about 4 or 5 types of indemnity clauses that are available in an LLP. So in simple, what is an indemnity? I don't have the time to discuss and ask questions to you. So I'll straight away say indemnity is nothing but a simple transaction where one party promises to save another party from the loss caused to the latter party. Okay. So the person who promises to save the other is called indemnifier, and the person whose loss is saved by the other person is called as the indemnified. Okay. Insurance is a typical example of an indemnity, right? So there are indemnity clauses. So in various situations in an LLP, one is that indemnity to LLP for fraud by the partner. So if a partner indulges in fraud, then he is liable to indemnify the LLP and the other partners for any loss caused due to the fraud. So that is the clause that is provided here. Then indemnity to LLP and other partners for a separate debt. Supposing one partner has a separate debt, he's taken a personal loan, but merely because he takes a personal loan will not make the LLP or other partners liable. So this particular clause says that the partner who has a separate personal debt shall indemnify the other partners and the LLP from any proceedings, costs, or claims in respect of such personal debts. Okay, then indemnification in the course of business is then indemnification to the partner, okay, by the LLP. So the indemnified here is the partner and indemnifier is the LLP. Whereas in the previous two cases, the indemnifier is the partner and indemnified is the other partners and the LLP. Okay. So here what it does, it says that each partner is indemnified in respect of payments made and personal liabilities incurred in the ordinary and proper conduct of the business of the LLP. Okay, or in or about anything necessarily done for the preservation of business or property of the LLP. See, the LLP runs the business of selling vegetables. Okay, so one of the partner takes a transportation, and is supposed to deliver say 100 kilos of potatoes to a place that is 500 kilometers away. But in the middle there is a roadblock, so for 2 days they cannot move. So this person finds out a huge refrigerator and then stores these 100 kilos of potatoes in there, and he incurs certain amount. Say he incurs 5 lakh rupees for 2 weeks. Now he is entitled to be indemnified for doing this on behalf of the firm from the other parties, right? So that is what this clause says. Then let's look at another type of indemnity in the LLP. A general indemnification says that LLP shall indemnify and defend all its partners and officers from any liability in connection with claims, etc., arising out of or resulting from the respective performance as partners and officers of so and so LLP, except in case of gross negligence or willful misconduct. So this is a general indemnity, right? So these are possible indemnity clauses that you could have in an LLP. Okay, now coming to cessation or retirement, various types of clauses can be there, but generally you have a clause which says that prior notice of 30 days is required. And if you want to cease or retire from the partnership, then partners can agree to waive off that 30-day prior notice and agree for a 15-day notice also. Then expiry of notice period, and then what is the effective date of the cessation then what about the business of the LLP? If one partner ceases, what will happen? Business of the LLP, its rights and liabilities, what will happen? Then the accounts vis-a-vis the said person, what will happen? Then what about the contribution made? That is the accounts due to or amounts due to or amounts to be paid by the resigning partner to be settled prior to the. So these are various ingredients that you could have in a cessation or retirement clause. Then let's move to assignment 3. By the way, in case you want to transfer a particular interest in that question, if you recollect, somebody had asked regarding ROFR and ROFO. So those will be detailed when we discuss the actual clauses. But this particular problem deals with that situation. So what assignment number 3 says, that is draft the following clauses on behalf of Mr. B. Okay. What is the fact scenario? We'll come to later. So you'll have to draft a meeting clause, then you'll have to draft a deadlock mechanism clause, Then you will have to draft a transfer restriction clause. Okay, these are three things that you will have to draft. What are the facts? ABC is a LLP, newly formed LLP that will engage in the business of providing IT consultancy services. Partners are Mr. A and B. A holds majority of 60%, B holds a minority of 40%. So in this fact scenario, you will have to draft these three types of clauses: meeting clause, deadlock mechanism clause, and transfer restriction clause. So what are the ingredients of a meeting clause? Meeting is basically meeting of the partners. So it will have the number of meetings within specific intervals. That is, say the clause might provide that the LLP shall have at least 4 meetings every year with not more than 3 months gap between each meeting. So it is possible. Then how to convene a meeting and what is the notice to be given, how the notice is to be given, then place and procedures of the meeting, where they should have the meetings, whether it is the registered office or elsewhere. Then quorum for decision making, that is how many partners should be there, and then decisions that may require unanimity, reserved matters, etc. Then who will be the chairman of the meeting, and if we will have the casting vote, then how will the voting be done, and whether proxy will be allowed, then how the decisions of the meetings will be recorded in form of resolutions, and circulation of the decision, how many days within which the resolutions are to be circulated, who will be the secretary. So all these things are being dealt in the meetings clause. Then deadlock mechanism clause. So what is deadlock? Deadlock is that the partners are unable to take a decision because there are two parties saying two different things, or two groups of parties saying two different things. So they're not able to come to a concrete solution. So in literary terms, deadlock means a stopping of an action because both sides in a struggle are equally powerful and neither will get. So in the deadlock mechanism clause, resolution clause, what are the things that will be there? Decisions that may require unanimity or some special voting, special votes other than the majority votes. Then when deadlocks can occur, and during the deadlock, how will the firm proceed? That is, if we preserve status quo, then notice regarding deadlock, who will give the notice, then how the deadlock will be resolved, then whether the resolution of deadlocks will be by all the partners or through a majority. So all these are dealt with the deadlock mechanism clause. Then we have the transfer restriction clause. So there is generally a prohibition on transfer or encumbrance of the partnership interest, LLP interest. Okay. So, say for example, nobody can encumber their interest in the partnership without the consent of the other party. So, this is the general provision. But there could be exceptions. Like, for example, one of your colleagues talked about affiliate. No, so the transfer restriction clause can say that, however, I mean, there is a restriction on transfer, but you could transfer it to your affiliate. Nothing wrong with it. Okay, that clause can say. Then, exception for a transfer restriction clause when the agreement itself requires compulsory transfer without consent, or when prior written consent is. So if prior written consent is taken from the other partners, then you can transfer or encumber your asset. So then what happens in case of there is a prohibition? You have your preemptive rights like ROFR, ROF1. So preemptive rights are rights that say if one partner intends to sell his interest to a third, transfer his interest to a third party, then that partner shall first offer those shares to the existing partner. So this is one type of a preemptive right that is there. Why you have it? Can you tell me why you have these preemptive rights?
So that if other partners, if the other partner don't want someone else to be a partner, so they themselves secure the right. So in case anyone wants to transfer his or her rights, then we'll get the first, right to get the share of the partner who is transferring it. So that's why.
So what happens in a partnership, okay, whether it's a partnership or an LLP, that is, one partner has the ability to bind the other partners. In case of partnership and in case of LLP, the LLP itself. So one partner's action can result in losses or profits to the LLP or a partnership firm. Okay. In both the cases, whether it is LLP or whether it is a partnership firm simpliciter, actions of one partner will have huge impact on the partnership or LLP and the other partners. Okay. So it involves a relationship of trust. Okay, so that is the reason why you would always want to choose partners whom you can repose your trust on, not on a third party whom you have no idea about, right? That is why there is a transfer restriction clause. Okay, so I have just run through these slides. So what we'll do in the next class is we'll draft actual clauses. Okay. So meanwhile, what you do is you take this week's time. I think next class we have on 6th. Okay. So there is exactly a week. I think it's next 6th is next Saturday. So you can make an attempt on drafting these clauses. And in case you've already done it, well and good, we can discuss those later. But in case you've not done, because out of 16, I've received only 4 or 5 of your assignments, and I'm not sure among those 4 or 5 also, you've addressed all these aspects, okay, in great detail or depth. So you can rework if you've already done it and see if you can do more. Then we'll meet you on 6th. Okay. In the meanwhile, if you, while doing your task, have any queries or something like that, you can mail it to me. Okay, I've provided my mail ID. If you want, you can note it down once again. Yeah. Badrinath@ebcpublishing.in or lawbadri@gmail.com. So either of it you can mail. I'll be checking my mails at least twice or thrice daily. So you need not worry about it. And whatever queries you have in the meanwhile, you can ask me. Okay. And if you think that you'll want to ask those queries in the next class, feel free to do so. Okay. Now the time is just 7:33. If you, I mean, I'm fine with spending a few minutes, 2 or 3 minutes, in answering your queries if you have any.
Sir, in that assignment, in the drafting the clause for the cessation and retirement thing, I had added a provision of sale of partnership interest also. So sale of partnership interest has to be separately drafted, or in under the same parameter we can add it. Like first I had added for retirement of partner and then the sale of partnership interest.
This is assignment 3, no?
Yeah. Assignment number 2.
2.
Yeah.
Yes,
The third question.
Okay,
Cessation and retirement.
winding up. It didn't ask for sale. It was winding up.
Yeah, I had added the sale of partnership interest in the just after cessation. So that has not to be added there.
No, that's not necessary. You can put it in transfer, because in transfer, what happens? See, one of the parties sells or transfers its interest either for some purpose or for money consideration.
Yeah.
Yeah. So that's you can put it in the third one. That's not a problem. Any other query?
So practically speaking, so we should make our agreements as much exhaustive as they can be, or we should
not necessarily. See, that's what I told you. See, you have 2 or 3 samples that were given to you. One was fairly simplistic. The other one, the Ambani sample, was like 50 pages. Okay, that really does not happen. See, in practice, what happens? See, you have a client who's going to run an LLP whose contribution is 7 or 8 lakhs. Let's just say initial contribution 7 or 8 lakhs. So for that, you don't need a 50-page agreement, no? You get it? So whereas if your initial contribution is like say 100 crores, and there would be so many permutation and combinations that your client would want to put all the possible situations that will arise in writing. So that is why that Ambani's agreement covers almost everything. Okay, you just take one clause, compare that draft, say let's say meeting. Okay, meeting clause, compare the meeting clause in the one sample with the other, you'll find a lot of difference. So see, there are certain things that you can just leave it as it is. Okay, you need not explicitly write it, but there are certain things that you must provide in your agreement. So it all depends on so many factors. One is what your client's needs are. Then the other is how much money they are providing to you. Say if they're giving you 1 crore rupees to draft this, then you can draft a 100-page LLP agreement also. Whereas they say that, look, I have only 5,000 rupees. So whatever LLP you want, you draft. So for that, you will not spend like 4 or 5 days. No, and draft a 50-100 page LLP agreement. So it all depends on factors, but then you should have a list of items that you think are essential in any LLP agreement. That is where your checklist will help.
Okay, got it. Thank you, sir.
Okay. So shall we close for the day? Okay, we'll close for the day, but don't worry. Please feel free to write to me whenever you want. Okay, and I'll try my best to reply to you in 24 hours. If I'm unable to do so, that means that your question is too good that I'm still finding answers even after 24 hours. Okay, so all the best. Keep at it. Keep at that assignment. Do it. Try it after this session. Let's see if you're able to come up with something better than what you have done so far. Okay. Bye bye. Good night.
Okay.
Thank you.
Thank you, sir.
Okay, sir. Bye.
Yeah.
And students, no, sir, thank you. And students, please do the assignments. It's like we keep on saying it every class. Please do submit the assignments within time so that we have time to go over them and prepare for your class. So please, for the next class also, please look at the deadline which is provided on the platform and please submit it by 3rd of May. Okay.
Yes.
Okay, sure.
Okay.
Okay. Okay. Thank you, guys. Thank you.
Ma'am,
Good night.
I had one question.
Yes.
Yeah, ma'am, actually, I had mailed you regarding the internship, and I had
Yes, we
mentioned
are looking.
physical internship as my preference, but I wanted to switch it over to online if you can provide me online internship in case.
Okay. Can you just drop in a mail regarding
Yes,
that?
yes, sure, ma'am. Sure, ma'am. Yeah.
Yeah. Okay. Take care.
Thank you, ma'am.
Okay. Thank you, guys. Happy weekend. And please do submit the assignments. Yeah.
Yeah.
Okay,
Okay.
okay, ma'am.
Thank you.
Okay, thank you.